Give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my right and your left is Justice Jim Milkey. To my left and your right is Justice Marguerite Grant. We will be the panel for the first two cases on our hearing list this morning. After the second hearing, after the second argument concludes, we will take a very brief recess for a panel change, and Justice John Englander will substitute in for Judge Grant. You may be seated. Each side of each case has 15 minutes to argue. We are familiar with the arguments that you've made in your briefs. We're familiar with the factual and procedural history in each case. You needn't repeat all of that. You may anticipate that we will have questions for you. There is no rebuttal. The podium includes a clock with a digital timer that will count backwards from 15 minutes to give you a sense of how much time you have left. The clock lights will turn from green to yellow when you have about a minute and a half left. At that point, if you haven't already begun to do so, it's a good time to begin wrapping up your argument. When you reach the end of your time, the light will turn red and start blinking. That is your indication that unless the panel has further questions for you, it's time to stop. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains. If you reach the end of your argument before you reach the end of your time, there's no reason for you to continue addressing us. And with that, I will call the first of our cases on the hearing list this morning, case number 2022 P799, DASILVA Enterprises LLC versus GINA M. Wright. This case is partially impounded. I'll just remind you that we are live streaming the argument in this case, as we do in all of our cases, and so if there is impounded material that's not suitable for exposure to the public, please refrain from reference to that material. You may begin.
Hi. Good morning.
Good morning.
I am basically here to, I just wanted to say thank you, Your Honors, for taking this case and letting me argue and hear the case. I'm sure you read all the papers and motions and all the paperwork.
Could you begin by clarifying one factual point? According to the docket of the Housing Court, there was an execution that was issued and levied, but there's a filing on the docket that says that at least when it was levied the first time, you were not evicted from the premises, yet your brief on appeal seems to indicate that you are no longer living there. Could you help us understand what happened? Are you there? And if not, why this case isn't moot?
Yes. What happened, Your Honors, is I was evicted. Well, the constable came down to have me, I guess, removed, but he didn't serve me the actual paperwork. And so my roommate that was staying with me had taken possession of the property, and he said I could stay with him. So it was almost like the property passed possession by my roommate, which was a little crazy at the time, but that is what happened. And then I went to the court and also went to try to get a stay from the bankruptcy situation, from the court at the bankruptcy. And at that point, I had the attorney, the third-party buyer, and his people all in my house, putting stuff in boxes, like telling my friends to get out. It was just a horrible situation. The whole thing was, from the beginning to that point, and then some. I did my best to, try to go by the letter of the law.
So are you still living there?
No, ma'am, I am not.
When did you stop living there?
I was removed, I want to say in June 2nd.
So why do we need to still decide this case if you're not living there anymore?
Well, the case was under a law. It was basically, I was put under a law that didn't apply to me, which was, I believe, 236, 239, 5, I believe.
I think Justice Grant's question goes to the following. The case is here for this appeal, challenging the correctness of an order of the single justice requiring payment of use and that was itself an appeal of an order requiring use and occupancy.
Right.
And there is nothing left to be done about that if you are no longer in the property.
Okay, but Your Honor, the reason I'm not in the property is because I was removed basically illegally. They had like no standing. When I was in housing court, the judge did not get any standing of the title. The title was gone. It's missing. They had,
But there was an affidavit to do with a lost note that the judge accepted.
That is correct, and that was like a prima facie evidence, I guess I would say. And also, I called that court. I asked them, because I went over that, the name on it, that was Sovereign's CEO or whatever, that person never worked there. It was fraudulent, I want to say that word. Because it was. When I called, they said the docket, there was no docket number on it, if you noticed on the affidavit. And when I called, they said that they never had it at, what's the state? Illinois. No. I'm sorry. It's just so much. The state, I think it was Illinois. It was like a state that I've never been to or anything. I just didn't know why they would use my name, somebody's name that didn't work at Santander or Sovereign, and put, it's almost like if I was driving down the street and I said, oh, I really love that house. Should I go, get a fraudulent title and slip it into the registry of deeds and then tell them they have to get out of their house? I mean, there's a lot of this happening, and it's horrible what the ripple effect is, And I'm not even, I know today might not go too far for myself, but there's a lot of people behind me and ahead of me that have been so hurt by this indigent court cost law, them not like even 239, like I even made copies for everybody to, maybe read the first couple lines together, because a lot of it don't apply to, if it didn't apply to me, a lot of it. I wasn't a tenant. I didn't sit down and make a contract with Mr. DASILVA,
Right. We are familiar. We've seen quite a number of cases that have involved the procedural intricacies of foreclosure and the title of the foreclosing entity and the transfer and assignments of mortgages that precede the foreclosure in some instances, and then, of course, the very complex statutory and procedural overlay that regulates the progress of post-foreclosure summary process actions, and then the review of those actions, including the effect of indigency protections in certain court costs. Yes, we see quite a lot of those cases.
Right. I think the last case that was in front of you was Ruth Ajardi, if I'm correct.
Oh, we've seen,
That was the
Ajardi
SJC.
was several years ago while Chief Justice Gantz was still with us. There have been quite a number of developments even since Ajardi.
Oh, okay.
Yeah.
Yeah. But, like, at this point in my situation, I've lost my home. I had to move out. All my stuff got thrown in a dumpster. You know, like, he was ordered to put it in a storage. He didn't, threw it away, have all that information. And then I had to file a bankruptcy, and now I have to pay him back, I think, like $24,000 on top of it. And it's just wrong. I never made the law on the indigent court costs and the bond and all that, it's a lot, you know? It's a lot to go through. And then pro se, like, I can't even believe how smart, I had a force to get smart to have to be able to come and try to save my, you know, situation, because I couldn't afford to hire an attorney, and you know what, not many will take a case like this, you know? I'm sure it's a lot of pro se, and it's a lot of hard work. I mean, my whole life changed, you know? It's big. And I just know that I never went to a court to determine title. I never went to land court or superior court at all. So for housing court to just remove me, like when I had Mr. DaSilva and we went through trial, I asked him all the things about the case, how he did his due diligence. He had all the paperwork I had. He agreed to everything that I had, you know? So I know he knew what was happening. And then for the bond, I know there's like 3 situations they could have done. They could have took care, financially paid him, I think it was. Hold on, I got some notes, sorry. There was, for the bond, I know that we can, it's not there just for wealthy people to be able to come to appeal your case, you know? I just feel very very tired and broken, and like I've been taken advantage of in.
One of the things, as I understand it, that the judge said in denying your motion to waive the appeal bond is that you had not shown a non-frivolous defense to raise on appeal.
Okay.
What are you saying is the non-frivolous defense that you have to raise?
Okay, a non-frivolous defense. So I know that the legislators had taken that out of the indigent court cost law, I believe. It's only in 239.5, which does not apply to me because then I never made a contract. I wasn't a tenant. I was the owner in possession of the house. So it was taking out, I believe, back the fibulous situation back in 90, hold on one second, Your Honors. Where did my note go? Oh, okay, it was 239.5. It was taking out only fibulous in 1996, 71, and 73, and 74, only because it doesn't apply to my situation. It was removed from the,
So
like,
just
the
to
SJC.
clarify, your argument is that even if you have no non-frivolous arguments on appeal, then you can continue in possession, if you were in possession, going forward during the course of the appeal without payment of any so-called rent.
Correct.
So you could just live there for free?
Well, there's nothing free about it. It was nothing free about it, Your Honor. No, until it was resolved, because when they did the law on how to charge somebody, it was like a time, almost like a time thing where they weren't sure how long it would take, and even if they won or not won, you know? So until the court was over, they didn't really know how much to charge. It was almost like two ends, like, okay, you would have to pay this much, and then you would have to pay this much, but we don't know if this person's gonna win the case, or they might not, and you know what I mean? And also, if they, when they asked, when I was in court and the judge had said that I would have to pay use and occupancy, she asked Mr. DaSilva how much he thought he should charge me. And he came up with a number and she said, that's fine. I thought that was a little, unheard of, but, the whole case was a little over the top. I just didn't, I'm not saying I should live there for free, but I'm saying until I straighten things out with the bank and the title and make sure the standing of the title is correct, then it shouldn't have gone so extremely ugly like that.
Well, I see that your 15 minutes has come to an end. We do have your arguments. I think we have a good feel for what's going on in the case. We'll hear from the counsel for the landlord, or for the
Okay,
owner. Yes.
thank you.
Good morning, Chief Justice, fellow justices. Attorney John Canavo on behalf of the plaintiff, DaSilva Enterprises. First thing which I'd like to address is what Justice Grant had said as to the occupancy of the property. Ms. Wright has been out of the property for a period of in excess of almost 15 months at this point in time. My client was an investor who purchased the property. He has subsequently sold the property and is no longer the record owner of the property. He sold it to a bona fide purchaser for value and is no longer owning of the property.
So are you the proper party as appellee in this case where you don't own the property?
Probably not, Your Honor, at this point in time. However, in light of her appeal, I can argue the facts as to those being made by her against my client.
And just to be clear, there's a lot that we've heard about that that has taken place in this case, but for the purposes of this appeal, this appeal is operating on a very narrow procedural question, as I understand it. We have an order of a single justice of this court that dismissed an appeal from an order of a different single justice of this court on the ground that the statute does not authorize an appeal from a single justice order of that type. And so the question in front of us is whether that order was correct, that the appeal of the earlier single justice order was final, as the statute seems to say.
And I would suggest Justice Desmond's order that was argued by Ms. Wright and myself here was appropriately issued. and then the justice.
Well, we're not reviewing Justice Desmond's order. We're reviewing Justice Walahojan's order, dismissing the appeal from Justice Desmond's order on the ground that the statute does not authorize an appeal from that order.
And I would concur that that is accurate, that there is no ability to appeal from that order. It was issued appropriately, de novo. She reviewed the orders in place, and I would suggest that this court is not empowered to overrule Justice Walahojan. I'm sure I mispronounced her name, and I apologize.
Walahojan, but and as I understand it, in her order dismissing the appeal, she identified alternative procedural avenues to raise the challenge to the propriety of Justice Desmond's disposition of the question for use and occupancy.
That is correct, and I would suggest that Ms. Wright did not follow those orders or do it in an appropriate fashion.
To a great extent, Ms. Wright relies on an unpublished opinion from a panel of this court, Silva v. Stanley. You don't actually address that case in your brief. It's not binding on this panel, but now's the time to address it if you have an argument.
I would say that in my opinion, and not that matters, that the Bank of New York Mellon King case is actually the case. For Ms. Wright to have succeeded on any appeal here, two criteria would have need to have been reached. One, that she would have been able to prove indigency, and two, that she would have had non-frivolous or she would have had a meritorious defense. I would suggest she fails on both prongs. She mentioned, and in light of her mentioning the fact she's in bankruptcy, I think it's relevant for the justices to understand what happened. If this home was the property that was foreclosed upon, she also owned the property where I was seated here. That is an unencumbered asset worth in excess of $550,000, which is involved in Ms. Wright's Chapter 13 bankruptcy. She's agreed in that case to satisfy the judgment in whole, the $24,000 that's owed to my client. There is no mortgages on that. She will own it free and clear with the exception of the judgment that my client obtained, as well as any taxes and municipal liens that may be owed to the city of Brockton. So for her to succeed under, whether it be Stanley or whether it be King or any case law that I'm aware of, indigency is prong one. And if she has an asset worth north of $500,000.
No, well, but a single justice of this court accepted, at least arguendo, her claim of indigency.
Correct.
Isn't that an assumption we have to make in this appeal, where there's nothing in the record about this other property or bankruptcy or?
I believe Justice Desmond's order referenced the property, and as Your Honor, as Justice points out, arguendo, yes, for the purposes of the statute, he presumed her to be indigent. But this case, as you can probably tell from looking at the multiple amici brief, the pleadings, and the underlying court record in the housing court, this was an extremely well-litigated case by Ms. Wright. The findings by Judge Theopolis in the underlying case were inexplicably clear. On the morning of trial, a minute before it started, she allowed Ms. Wright to amend her pleadings to include affirmative defenses. So any possible defense that she could have raised, and as she's trying to say today, whether or not she owned, whether or not title was proper, those matters were decided at the trial court level. And I would suggest that there is unequivocally no defenses that would not be.
Did her answer include account for Equal Protection Clause violations and gender discrimination that she argues now in her brief?
I have to plead ignorance. It was a myriad of affirmative defenses that were raised. There were a lot of them. They were a little disjointed. So I have to plead ignorance on that, Madam Justice. I'm sorry. Again, I think the law in the Commonwealth is clear, whether it be in this court with published and non-published opinions, as well as the Supreme Court. I believe this court could determine her appeal to be moot as a matter of law, and if this court chooses to issue a decision in arguendo, I would suggest that she has not met her burden of proving any meritorious defenses.
Now, just on the mootness point, the judgment here did require payment of the $24,000, and you're representing to us that she agreed to pay that as part of the bankruptcy case, but we have nothing in that case, I believe, before us. So at least on the record that is before us, this case is not moot, is it?
You are correct. Her bankruptcy filing was relatively recent. Certainly after it's been filed, certainly subsequent to Justice Desmond's appeal as well as the review. So her bankruptcy is of relative recency. I have nothing further unless the justices have questions.
Nope, seeing no further questions, that concludes the argument in this case.
Thank you very much.
We move to the second case on our hearing list this morning, case number 2023 P382, BLACKMAN'S POINT HOMEOWNERS ASSOCIATIon, Inc., and others versus Nancy BLACKMAN Call and others.
Good morning, Chief Justice. May it please the Court. At a minimum, this case must be remanded because the trial judge failed to apply the presumption of retaliation, failed to apply the clear and convincing standard for rebutting the presumption, and failed to put the burden of proof on the defendants to show a good faith discontinuance. But going beyond that, I believe the plaintiffs are entitled to judgment as a matter of law and a remand for the purpose of calculating damages and awarding injunctive relief. I'd like to start, unless the Court feels otherwise, with the implied incorporation theory that was the basis of the summary judgment ruling. The contract here, the settlement agreement from 1988, is complete on its face, and it provides for two methods of termination: by sale of the property to a third party or by sale to the association, my client. It did not provide for termination by discontinuance without a sale. The Blackmans claim that the contract was missing an essential term, and that the missing term had to be supplied by reference to the statute. But the contract language was clear, and therefore there's no missing term. In addition, it is an integrated contract. Paragraph 22 requires a signed written agreement to amend, waive, or modify it. The settlement agreement in 5 separate
Can I just interrupt you for a sec? Implicitly, at least, your argument seems to be that unless they sold the property, I'm talking about the 1988 agreement,
Yes.
Unless they sold the property, they could not change its use under the agreement. Is that?
That's correct.
Okay, and was that forever? 100 years from now, they still were locked into that use? And if that's your argument, doesn't that run up against a lot of principles in property law that you can't restrict the use of the property in that manner forever?
Well, you can't restrict alienation of the property, but they were free to alienate the property. They were free to sell at any time. And they were required to continue operating as a mobile home park, which is what they had been doing when the agreement was signed.
Now, for that proposition, are you relying on the future lease language or paragraph of the 1988 agreement?
I'm relying on paragraph 7 says, in each year succeeding 1988, in which the Blackmans do not notify the association by April 1 of a bona fide offer to buy the property, the Blackmans hereby agree to reopen the park. And it goes on to say that paragraph 12 says, until such time as tenancies are terminated pursuant to paragraph 10, which I'll get to, or until the property is sold to the association, the Blackmans agree that they shall obtain all necessary operating licenses as may be required for the continued operation of the park as a mobile home and trailer camp, which is the old language for manufactured housing community, and otherwise comply with all local, state, or federal requirements. Paragraph 10 says that the tenancies of the tenants will terminate 60 days after conveyance of the park. If the right of first refusal either does not apply or terminates because it has not been validly exercised by the association. And paragraphs 11 and 13 also refer to the functioning of the park prior to the sale of the property by the Blackmans. Paragraphs 13 also says until the tenancies are terminated, under paragraph 10, the association agrees that it shall undertake all routine maintenance and repairs of the park.
Mr. Solomon, let me just see if I can focus you, though. I understand your argument, but I want to hear what you have to say in response to the argument of the owners, who, if I understand the argument correctly, say that there is a statutory right to discontinue the use of the property, and because the contract does not explicitly abrogate the right created by statute, that therefore the judge correctly viewed the contract as creating a gap that allows the statutory right to survive the arrangement reached by the parties in the settlement agreement in 1988.
I don't think there's any requirement in law that you cannot have a contract that goes on for an indefinite period of time. There are
the rule against perpetuities, but there was a provision in the settlement agreement that, as I read it, it invoked the Kennedy family, and it seems to me that was designed to address any question about the rule against perpetuities.
Yes, and of course that particular eventuality has not yet come to pass. So
we see in the newspapers.
So we see. But the defendants raised a perpetuities argument. They raised an argument that the agreement was an unreasonable restraint on alienation, and they also called it a negative easement, which it is not. We opposed all of those, and the parties argued all of those things to the motion judge. And the motion judge and the defendants in their filing, in their summary judgment filing, said that the right, that they were asking for the right to discontinue, but they said this will require subsidiary findings on alienation or perpetuities or negative easements. Well, the motion judge did not make any such findings. The motion judge simply inverted it and said, I'm going to allow them to use the statute, and I don't have to make those findings. I don't have to make any findings on those issues. But the rationale for substituting a missing term of the agreement is that the contract lacks something, and in contract modification cases, there may be a missing definitional term. There may be a
well, it doesn't use the word discontinuance.
The contract does not use the word discontinuance. It doesn't say you can, and it doesn't say you cannot. Now, the overriding duty in a contract case is to give effect to the contract the parties actually agreed on, unless public policy forbids it, and they have not made an argument that public policy forbids it. And there's no reason or justification to insert additional provisions that the parties might or might not have agreed to at that time. Let's take the hypothetical. What if the parties had actually talked about this issue at the time the agreement was being negotiated? And one side proposed language that said, notwithstanding anything else in the agreement, we may discontinue under the statute. And the other side is asked to agree to that. Would they have agreed to it? Well, I don't think we know for sure, but the agreement was there to settle a litigation matter which was heavily litigated and which involved a proposed discontinuance of the park. So I don't think it's likely that the tenants would have agreed to that.
You're not asking us to rewrite the contract to incorporate terms along the lines that the parties would have addressed had they addressed them.
Well, that's something the court, I think, cannot do. The court can only construe the contract, interpret it, but it really has to be the contract.
Our charge is to construe the parties' agreement and also the parties' rights and obligations that arise from sources outside of the agreement under common law property doctrine and also under statutory overlays as they apply.
Well, the agreement, in my view, waives certain rights that the parties might otherwise have in the absence of the agreement. Any contract does that. If you agree to, if you're a performing artist and you agree to perform in a certain venue on a certain date, you can't decide you want to perform in a different venue on that date. You've already made a contract.
You want to avoid personal service contracts
Yes, we do.
for purposes of your analogy because there are a whole
But,
series of
yes,
different principles that apply.
I realize that, Your Honor. Any agreement involves a waiver of the right to do something contrary to the agreement. The agreement says, in every year, you shall reopen the park. And so the only way to interpolate a discontinuance right is to say that the defendants had the right to avail themselves of the discontinuance statute, notwithstanding the fact that the agreement does not say they have the right to do so. And the only cases under that are cases involving the impairment of contracts clause of the U.S. Constitution and public employee contracts or public contracts of any sort in the Commonwealth. And there have been a few cases where, in cases where the statutory age of majority was lowered, and the issue was, did that change apply to a divorce agreement? But in terms of the basic issue of whether an agreement can be terminated by some cause that the parties did not agree on, parties who were in the midst of settling litigation, there is no reason to interpolate a term that they did not agree upon. It simply would upset the entire basis of that settlement negotiation. If the tenants had proposed a term saying that you cannot discontinue, would the landlord have agreed to it? They might well have, because the agreement otherwise says you're going to open the park. It's the agreement in at least 5 paragraphs is inconsistent with with a discontinuance obligation, and the basis for bringing the statute into it is just based on a line of cases that does not apply. If that line of cases applied to every contract case, we'd see agreements being rewritten a whole lot more.
I have a question for you. So, as I understand it, the Blackmans could get more for the property if it were vacant, if the
Yes.
mobile homes were gone. But the homeowners have the right of first refusal, homeowners association. What would happen if, hypothetically, the Blackmans sold the property as is to the right of first refusal, to the homeowners under the right of first refusal? Could the homeowners then turn around and vacate the property and sell it for more? Resell it for more?
If the homeowners bought the property,
Correct.
there's a provision in the agreement that says that if they sell it within 5 years, they have to pay the Blackmans basically a penalty for doing so. So the understanding is that they would continue to operate the park as it is.
But just to be clear, if the homeowners purchase the property pursuant to the right of first refusal or to a negotiated agreement outside of the right of first refusal, they would not succeed to the obligations held by Blackman's Point by the Blackmans under the settlement agreement. The settlement agreement would cease to govern the obligations on the property owner if the homeowners association purchased it.
I think it would, because the association would be the identical party on both sides of the agreement, and therefore the rights and duties would be meaningless at that point, except for the provision that would penalize them if they turned around and sold it.
Within 5 years?
Yes. I do want to take a few seconds just to go through the statutory discontinuance issues. The Blackmans admit, as Your Honor noted, that they had a profit motive to empty the park first and then vacate it, and then sell. So they wanted to sell. They did not communicate that in their notice of discontinuance, and they therefore violated the statute in doing so. They also, the other question is whether they could discontinue without a stated reason. And the admitting that they had a profit motive makes it clear that they were not being restrained from selling the property. They were being restrained from selling it without the tenants in place and able to exercise their statutory rights or their rights under the recorded right of first refusal. And then what would stop the Blackmans if they did discontinue?
I think we'll have to leave it there.
Thank you, Your Honor.
Your Honors, may it please the Court. There's nothing in this statute which says that the Blackmans must sell the property before they discontinue the use. We have a case, as the trial judge found, at the intersection of this agreement in 1988.
I have a little difficulty, Mr. Broadley, with the foundational premise of your argument.
Okay.
It seems to me that the right to discontinue the use of the property is inherent in the ownership of the property itself. The right to discontinue is not a creature, is not created by the statute. Instead, the statute imposes certain restrictions or limitations on a right that otherwise inheres in the ownership of property by its nature.
I agree. I agree.
Now,
Okay.
the owner of property may, by contract or by other means, including a restrictive covenant or some other mechanism, voluntarily relinquish rights that would otherwise be inherent in the ownership of the property. Mm-hmm. Isn't that what the 1988 settlement agreement precisely did?
No. The settlement
There are a
agreement-
variety of different rights and obligations that the parties agreed to in the 1988 settlement agreement, including, as you've just heard, and as I'm sure you're aware, the obligation to continue operating the property as a mobile home unless there's notice of an intention to sell by a date certain of each year. That was a voluntary limitation on the right to discontinue.
So in at least 3 different places in that agreement, it says language substantially like this. For every season in which there has been no notice of sale, they agree to so on and so forth. What it doesn't answer is the question, what if there isn't that situation? What if something else happens? And we were, as Mr. Solomon clearly argues, we were in 1987 and 1988 having a big fight about discontinuance.
Right.
And this statute is referenced in the resulting agreement. And
Statute doesn't create a right to discontinue. The statute limits the right to discontinue, and as part of this settlement, in order to resolve that lawsuit about a proposed discontinuance, you agreed not to discontinue. At least that's the way the language seems to read. And it seems to me that you acknowledge that in your brief and suggest that that couldn't have been what it means.
I don't read anything in the agreement which expressly waives a future right to resort to the statute. And in fact,
No, you're talking about resorting to the statute as though the statute created a free-floating, unencumberable right to discontinue. And as I thought we had, maybe you disagree with my foundational premise that the right to discontinue, absent a voluntary agreement to the contrary, the right to discontinue is inherent in the ownership of property, and what the statute does is places limits on that right.
it says how we have to do it if we're going to do it.
If you're going to do it. But that does not itself preclude a voluntary agreement not to discontinue. And the voluntary agreement not to discontinue it seems to me, was what the 1988 settlement agreement was all about. I can direct you to the specific provisions that give me that impression, and you can tell me why I'm wrong.
Well,
Paragraph 10.
In my view, Your Honor.
Paragraph 7. In each year succeeding 1988 in which the Blackmans do not notify the association by April 1 of each such year of any bona fide offer to buy the property that the Blackmans intend to accept, we agreed that that didn't happen here, the Blackmans agree to reopen the park for the period from May 1 through September 30 of each such year. That seems clear enough to me, straightforward enough, unambiguous enough.
Right.
And the same concept is carried forward in paragraph 12 that lays out a series of detailed provisions about not just the fact of operation, continued operation, but the manner in which that operation shall take place.
And my view of the language in that agreement is, if this association was so concerned with what they viewed was an improper discontinuance process by my clients in 1987, it should have been an explicit restriction saying you may not discontinue the use.
So unless they used a form of the verb discontinue, there's no discontinuance mentioned in the contract?
The Chief Justice is reading an implication, I see, into language that I say, if that was a big deal for them in 1987, they should have made that an explicit. They reference the statute.
What's not explicit? I mean, you're saying they should have said may not discontinue, but and instead the agreement simply said shall continue. Now, I understand that the one is a simple, straightforward affirmative obligation. The other is a double negative that achieves the same result. But I'm not, again, immediately seeing the distinction that you seem to place.
And that is why we made the arguments that we made to the motion judge.
I know why you made the arguments, and what I'm having difficulty with is why the motion judge accepted them.
Because he took the additional view that the existing law provides for a, notwithstanding private agreements, it provides for the fact that these kinds of organizations, these parks, can be discontinued. And that
in the absence of an agreement, to the contrary.
And where that statute
certainly is true.
And where the statute is incorporated into the agreement, and the parties agree that it governs them, and in the early part of 2018, the same trial judge and all the parties agreed that this statute is enforceable against the plaintiffs.
Let me shift gears for just a moment, because there's another argument or another question that seems to be kicking around in this appeal that we haven't touched on yet, and that is the validity or the effectiveness of the notice of discontinuance itself, even under the statute. And there, in a nutshell, the suggestion is that under the, what is it? Is it the Allen case? Quinn case. a notice of discontinuance must describe with some degree of particularity the proposed new use. And this notice of discontinuance did not describe a proposed new use. Instead, it said that we are discontinuing for the purpose of selling. But a sale is not a change in use, it's a change in ownership.
Well, if our change of use is we're not going to use it anymore, and we're going to sell it to somebody else to
That's
use.
personal, it's not, it doesn't tie to the property. I think
don't
if you
think-
look at the area of land use regulation, particularly zoning, there is a very consistent through line that says that a change of ownership does not constitute a change in use.
And the conclusion of that would be that my client would have to retain ownership and use it for something else. They couldn't sell it then.
The suggestion is that under the statute that you seem to be arguing allows you to change the use despite the agreement to the contrary, the notice of discontinuance needs to specify the proposed new use in order to be an effective notice of discontinuance. But here, the notice of discontinuance did not specify a new use, it specified an intention to sell. In other words, specified a change in ownership, not a change in use.
Is it your position that an intent to sell is a change in use?
It's my position that my client's change in use would be, we don't want to use it anymore. We want to sell it to somebody else who will use it for some other purpose. That's what we want to have happen. We don't want to keep it and make a new use. We would like to sell it.
Right, but you have not identified, you could sell it. You simply have to identify a buyer, bona fide purchaser with an offer to sell, indicate that you have an intention to accept that offer, and then, under the right of first refusal, allow the homeowners association to match that offer. That didn't happen here. That's not what we're talking about.
No,
You
we're not.
instead sent a notice of discontinuance toward a possible future sale that would be outside of the right of first refusal. That's not a change in use, that's a wish to discontinue the use, but without specifying a new use, just a wish to sell the property.
So that reading of the statute says that we can't just sell it. We can't sell it to make more money. We have to only sell it. That says the statute reinforces this agreement. We're bound only to keep this and do the same use until they buy it.
No. Let's take the agreement out of it. The statute, as I understand it, and again, under the Quinn case, says that if you're going to discontinue the use of the property as a mobile home park, you need to send notice of the proposed, of the wish to discontinue and the proposed new use. And that new use was not specified here. What was specified was a desire to sell, not a different use.
And I say that going to that conclusion means that we don't have any choice. We really, that the statute
You
doesn't.
do. If you said, I want to put up a Walmart, that's a new use. If you said, I want to build an apartment complex, that's a new use. If you said, I want to build an Amazon distribution facility, that's a new use. But saying, I want to sell to a different owner, that's not a new use, that's a new owner.
So it restricts us by this reading.
That's the statute that you are saying gives you the right to discontinue. I'm not doing that, that's the statute. As construed in the Quinn case, at least.
Well, put another way, what do you say in response to the Attorney General's amicus brief that says, under the statute, you have two options, or the Blackmans have two options. One is under 32R, sell with the right of first refusal to the homeowners or a third party, or under 32L, notify the homeowners of the planned alternative use, and that neither of those has happened here. What do you say to those arguments?
I say that the trial judge looked at the whole situation and took the reasonable course. She didn't have much guidance. And she said, okay, you gave a notice in March, certified mail, said what it said. You gave a notice in June, it said another thing. But they're not contradictory. between the two notices, they gave the residents of the park, or the campers in the park, they gave them notice that we were going to sell the property and that we were going to discontinue the use. The two notices together, 75 days apart. And I think the factual situation in our situation is different from the Quinn case, which was multiple owners spread all over the place, a lot of contradictory notices. I think that the trial judge was correct to say that between the two notices together, this park, these people, it's a small park, about 140, 150 sites. They knew what was going on. They knew that the Blackmans wanted to sell. They knew that the Blackmans wanted to discontinue. They knew the Blackmans did not want to run the park anymore. This was not a secret. It was not tricky. The notices were not confusing. And
No one is suggesting deception here. I mean, well, at least no one on this panel, in the questions that we've asked, are suggesting bad faith or deception. It's simply a question of whether, if we accept your argument in the first instance, that the statute creates a right that may not be limited by contract to discontinue the property. We are asking whether the form and manner of proposed discontinuance satisfies the limitations imposed by that statute on how a discontinuance may occur.
Neither the statute, as I read it, nor the regulations say that the notice in quotes, has to be a single piece of paper, has to be a single letter. You have to give notice.
It's not a question of single letter. I'm going more toward the substance, taking all of the notices written together. As I understand the statute and the Quinn case, the notice of discontinuance must advise what the proposed new use will be.
And I take your argument about a new use, a sale, not being a new use, but my response is only that if that is the definition, then what happens is my clients really have no way to get rid of the property. They must keep it. They must either go through the process in the agreement, or they must themselves decide they want to develop the property in some other way. They're not free to sell it on the open market after discontinuance.
They can sell it occupied for less money.
They can sell it after they redevelop it, or they can sell it occupied as it is now for less money.
Subject to the right of first refusal, right?
Yes.
All right.
I have a,
Okay, go ahead.
assume, shifting gears back to where we were before, assume that the panel agrees, and I don't know if this is the case, that the 1988 agreement prohibits your clients from discontinuing the property. I understand that Judge Michaud didn't reach your arguments about the rule against perpetuities and restraints on alienation and negative easements and all of that. Would we need to remand for a determination of those issues?
Very good question. They haven't been addressed, that's all I can say in response to that. They have not been addressed.
All right, thank you. That concludes our argument in this case. As I mentioned at the opening of this session, we will take a very brief recess for a change in the panel, and we'll resume with the argument in the third case when we return.
All rise.